What are your rights as a buyer if you discover that the property you are buying has unapproved renovations or additions? Hi, I am Gary Chen and I am a solicitor at Alliance Compensation and Litigation Lawyers. Many properties may have had some form of renovation or addition done. Common examples of these are granny flats, pergolas, sheds, and swimming pools, as well as possible conversions of a garage into a living room. Under Section 52A to B of the Conveyancing Act, vendors are responsible for making sure that no building or structure included in the sale of the property is subject to an upgrading or demolition order from the local council. But what if the vendor failed to disclose unapproved work or structures? What protection do you have as a purchaser? In today's video, we will talk about it and more. But before I get into the details, you should know that the information included in this video is not intended to serve as a substitute for consultation with a lawyer. Specific legal issues, concerns, and conditions always requires advice from appropriate legal professionals. Okay, let's get into it. Let's suppose you have just found your dream home, but when you start to do your due diligence, you realize that the previous owner made some unapproved renovations or addition to the property. Now, what would happen next? Well, if the vendor doesn't disclose unapproved work or structure on the property, and if this was not mentioned in the contract, then you as the purchaser have the right to cancel the contract and get your deposit back. This applies as long as certain conditions are met according to Regulations 16(1)(b) and 17 of the Conveyancing Regulation. One example of this is the case Huang and Sealand 2018, wherein the vendor put their 3-bedroom unit up for sale. The development approval allowed for the apartment to have 2 bedrooms, but a wall had been constructed to turn an open media room into a 3rd bedroom. The purchaser found out about the unapproved work after exchanging the contracts. The Supreme Court found that the vendor had breached his disclosure obligations by not telling the purchaser about the work. As a result, the Supreme Court ordered the return of the purchaser's deposit. So what if you, the purchaser, were informed of the unapproved works and structure on the property? Well, if that happens and you still decide to enter into the contract, you are saying that you acknowledge that you are buying the property as it is. This also means that you lose your right to rescind for the breach of vendor warranty. On top of that, you also need to be aware of the following consequences. Firstly, the local council may at any time require you to fix or demolish any improvements made to your property without their approval. This includes improvements made by you, someone else, or even a previous owner. Secondly, rectification works due to upgrading, demolition, or work orders issued by the council can be very costly. And finally, it might be difficult to find a buyer for the property if you choose to sell it later. If you are unsure if a structure or work on the property was approved, you can buy title insurance to protect yourself financially. The insurance has a one-off fee and will safeguard you for the lifetime of owning the property against illegal or incorrectly built structures and other issues. So if you are looking to buy a property, our property team can assist you during the process, especially before you sign the contract. That way, if there are any issues with the property, they can be discussed and the contract can be amended or cancelled during the cooling off period. Just get in touch on 8764-1776 if you have any questions. I am Gary from Alliance Compensation and Litigation Lawyers. See you next time.